If you've ever been convicted and sentenced in federal court to a term of imprisonment, that custodial sentence will usually be followed by some term of supervision. In federal court, we call that term supervised release. There are going to be conditions of supervised release, as well as a probation officer assigned to your case supervising you. The most common conditions are not to violate any federal, state, or local laws, do not possess or use controlled substances, there may be some drug testing involved, pay any fines and restitution, and so on. Sometimes the court will also impose some special conditions. Nevertheless, you must follow all of those conditions, and if you violate any of those conditions, you will then be brought before the court for a revocation hearing. Today we're going to discuss what to expect at this hearing, and we will focus on a case where an individual argues that he has a right to a jury trial, so the government actually proves that he violated the conditions in front of a jury. So we're going to talk about supervised release in general and then focus on this case. And before we go on, I want to thank you for watching me here on YouTube. If you're new to the LAWSTACHE channel, please hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to lawstache.com and check out some of the merch, including the Do Not Arrest This Person t-shirts, stickers, and some other items. Thanks for watching.
Quick message from LawStache. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the LawStache YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the LawStache YouTube page. That's LAWSTACHE.
Today we'll discuss supervised release revocation hearings, and then we'll focus on United States v. Bowers case. First, let's talk about supervised release revocation hearings. If the probation department believes that you violated some term of supervision, they will bring allegations against you in front of the court. The judge then has to determine three things: whether the violation has occurred, whether revocation is appropriate, and what is the penalty. One thing you can do, of course, is admit to the allegation, but if you say that that's not true and you deny the allegations, then a revocation hearing will occur. At that point, you have certain rights. Specifically, you're entitled to a written notice of the alleged violations, disclosure of the evidence against you, an opportunity to appear, present evidence, and question adverse witnesses. You have a right to counsel at this hearing, and the opportunity to make a statement and present any mitigating information. Now let's focus on the Ninth Circuit case United States v. Bowers. In 2019, Mr. Bowers, pursuant to a plea agreement, was convicted of possession with intent to distribute heroin in violation of 21 U.S.C. section 841. He was of course convicted and then sentenced to a term of imprisonment of 36 months. After spending 36 months in prison, he had a 3-year term of supervised release. During that term of supervision, the probation department alleged that he violated the terms by, number 1, committing a 4th-degree assault, and number 2, violating protective order in the state system. While the parties were waiting for a revocation hearing, Mr. Bowers actually resolved the state case. He entered a deferral program where he did not have to admit guilt. Now, a few months later, the revocation hearing occurred, and at that time, the government and the probation department presented evidence against Mr. Bowers. The court found that he violated the conditions and then imposed an additional 9 months of custody. Of course, at the hearing, Mr. Bowers had all the rights that I've enumerated earlier, but he said he also had a right to a jury during the revocation hearing. He said that he has this right under the Sixth Amendment as well as Article 3, Section 2 of the Constitution. So before we go on, let's look at these sections and the Constitution itself. In our system of criminal adjudication, one of the most fundamental and sacred procedural rights is that of a trial by a jury. Our founding fathers considered this right so important that they enshrined it in both in Article 3 of the Constitution and in the Sixth Amendment. Article 3, enacted in 1787, states the trial of all crimes, except in cases of impeachment, shall be by a jury, and such trial shall be held in the state where the said crimes shall have been committed, but when not committed within any state, the trial shall be at such place or places as Congress may by the law have directed. As relevant here, the Sixth Amendment, which was enacted in 1791, states in part that in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. If you paid close attention to the language, you realize that the Sixth Amendment talks about criminal prosecutions. Because a revocation hearing is not a criminal prosecution, the jury right does not attach. But Mr. Bowers argues that the Constitution, and specifically Article 3, Section 2, talks about all crimes, and thus he should have that right under the Constitution. But it is important to remember which came first. Of course, the Constitution was written first and then followed by the amendment. After the Constitution was drafted, there were some fears that the government can bring secret trials or postpone trials indefinitely, or finally bring in hearsay instead of live testimony. To address some of those concerns, the Sixth Amendment was drafted. And of course, now we know that it has to be a public trial, and so on. So the Ninth Circuit, as well as many others, have said that the Sixth Amendment should not be read to compete with the Constitution. Instead, it complements the Constitution. And so, together, the Ninth Circuit says you do not have a right to a jury at the revocation hearing. I hope you enjoyed learning about supervised release and revocation hearings. You now know that you have certain rights at these hearings, but having a jury is not one of them. Because you're exposed to an additional term of imprisonment if you violate a term of supervision, I always encourage you to give me or another reputable attorney a call if you're facing allegations in the Southern District of California. If you enjoyed this video, you've learned something, give it a thumbs up. If you're new to the LAWSTACHE channel, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to lawstache.com and check out some of the merch, including the Do Not Arrest This Person t-shirts, stickers, and some other items. Thanks for watching, and I'll see you next Wednesday on another deep dive on another criminal case. Thanks for watching.